I don't have to go in depth regarding what is a trademark. So we all know there are different types of trademark, right from word mark to even smell marks, which is not rightly practiced in India. In India, so far we have this sound marks being registered. So these are different, very prominent trademarks that we have for the day. And what is the latest growth in the trademark registration system? You can see some of the highlighted words, the areas where we are working upon. First, whenever any person wants to file a trademark, please go and use the tools and techniques that are available in the public website that I would be moving upon. So this rules 2017, they have come up with several efficient system. Right from previously, it should have been around 72 forms, which were the advocates were trying difficult to file, and even right now, even I've been working for the last 5 years. Even I don't know the 72 forms because I came after that. And digitization. So previously it was all the registers where they were looking onto it, but right now it's just in one click you can look what you actually looking for. That is one of the things. And expedited process, and with this online filing, it's just if you have a class 2 digital signature, you can just sit in your place and do whatever you want, just file and do all the even hearing works and everything. And I'll just move on to the tools and techniques. First, what we have to do, yes, see this is the page where you can, the official website, the different tools where you can actually search. So first, you can see that related links and quick informations where you can just look for the fixing of your class. So as I said, you can see in the previous slide that there are 45 different classes. The first 1 to 34 deals with the manufacturers. So please don't, why I am very particular about this is that people, they just give some wrong information which causes the delay. It's not because of the office, it's because of the applicants who are doing it. So it's 1 to 34, it's about the goods which are actually manufactured. And 35 is the for the retailers for who do not manufacture, but they are just playing in the market. And the last one is, you can look at the picture and get it, it's the service providers. Right from doctors to even beauty salons to legal services falls in this category. Okay? And then whenever, okay, I don't have to explain this. I think most of you can read what it is. I'll tell you. So whenever you file something, any trademark, there are some preliminary objections that are being raised by the office. So just make sure that you don't have these words, and this particular scene will tell you indirectly how a trademark can be. You can see those words, ingu nalla meengal. So ingu, it directly says the location of a place, right? So say a good trademark shall not have the name of a place. Right. So we from the office, we raise an objection asking you to delete that word in the examination report that we issue to you. So we would be asking. So this is one of the reasons why we are objecting your trademark. So we ask you to delete that word ingu, which refers to location in English, and then nalla. So nalla means we know it's an adjective. Right, you cannot sell your cell phone saying that it is the best phone, it's a smartphone, because it's all dictionary words and it's generic words. No one can claim any full right over those words. So we again we raise objections on that basis. And then meanwhile, what is this? See, for example, you take the example of Apple. See, the Apple brand, now we have come to a stage that the word Apple just remains of the mobiles or computers. We forgot the fruit itself. So we tell you to, it's very, it's under 9(1)(b), if you have file you must be knowing about, it says what you're doing. It's very obvious, it's not a good trademark. So on this basis, we ask you to delete, or we say that you have been objected. And then it goes to the next level. So if these things are taken out from your logo or trademark, so one part you have cleared. And we move on to the next similarity. So make sure that your trademark doesn't have any of these. If it is having means there are certain criteria that it should have attained, so that we can give on this basis, maybe considering as a whole or some other criteria and on how different it is from them. Or the mark should have attained secondary meaning, like India Gates, or something that it has been in market for a very long time and it has acquired a secondary meaning to it. And then the similarities. So this is objection that we raise under the section 11. So what makes us to do is that there are already similar marks existing in them. So whenever your client comes to you for registration of trademark, there itself you can again go back to this, you can go to this, first you can fix the class. For example, if anyone is coming to you with textile branding, so textile you can just check. If you don't know the class, you can just go to nice classification, you can find out, and then you can put it in search it through public search. So in public search, you would be able to see whether any similar brands are already existing in the office or not. So you can come to a conclusion whether it's easy for you to get an registration certificate as soon as possible. So up to this stage only, it is in our hands, that is with the office and with the applicant. So these are the three stages where we have this examination, palm section and show cause hearing, where the trademarks are accepted from our office. So now the examination is centralized, so in Mumbai. So whenever an application is being applied, so at the time of examination itself, a trademark application would be accepted and advertised. So that is the first stage where it is being under scrutiny. And then at the palm section. So what happens at this examination section? So in this examination section, they just go through the applications and they see if there is anything to be objected, just like we saw those places or anything related to public obscenity or any other relevant objections. And then 11 objections. So if there is no objections to be raised, it would be immediately accepted at the stage of examination itself. And then this palm section. What is this palm? Pending application report module. So here the major problem that I have come across, what I want to share with you is that we issue an examination report saying that you have to do this or delete or include or give some appropriate detail. So what happens is that they will file a TMM. Of course, they are being asked to do some TMM for that, to file a TMM. They just file the TMM and they leave it. After a very long time, even after 1 year also, I have seen the reply being filed, because in the examination report, we ask them to file a reply to the palm section. But they think that just complying and as per the examination report is alone, so that it doesn't move to the next section at all. So if you are just filing the TMM and leaving without filing the reply, in reply you can just mention just a word that yes, you have complied with the examination report. That even that is sufficient, if that is the case. So it never moves to the palm section. If only you give a reply, it moves to the palm section. Otherwise, only the TMM would have been completed and it remains for a long stage in the state of objected. So after the palm section, so what happens in this section? So in palm section, you come with a reply and you come with the complaints given, and then we see if it is satisfactory. So what is being asked by us, if you are complied with that, well, we accept the trademark at this level also. And then if there is any due in that, we want some other information or we want some other clarity, you may easily say that no, that's our sister concern, that's our family business or anything. But from our office, what we expect is that whoever they are, we want a proper declaration or an NOC from them, so that they are all different legal entities. We have to see in that perspective. So you may claim that yes, you are all one and the same, but we need some legal documents to move ahead. Later on, there shouldn't be any problem. So and then we fix for show cause hearing. So in this show cause hearing, again, either it would be refused or it would be accepted. So these are the three stages where the trademarks are usually accepted. So till this level, I can assure you that without any hassle, you can get your trademark accepted at least within a month, within a period of 1 month or 2 months. Because even to achieve this stage, people take some years or even decades.